could take a seat, that would be great, and we'll get the program started. We've got a lot of content today, so we're going to try to stick as close to schedule as we possibly can. While everyone's taking a seat, I will introduce myself. My name is Gordon Platt. I'm the president of Gotham Media, which today with Bill Rosenblatt and Giant Steps Media Technology Strategies, we're holding the second annual Copyright and Technology event. We did our first one last year and got such great feedback from it that we decided to make it an annual event. I'd first like to, of course, thank everybody for coming and thank our panelists for coming as well and presenting today, and especially our sponsors for making today's events possible. Well, without further ado, I'd like to get the ball rolling and turn it over to Bill Rosenblatt, who will get the program started and kick off the presentation. So, Bill, without further ado.
Thanks. Thanks, Gordon, and welcome everyone. It's really nice to see everyone here, and it's nice to see some semblance of autumn return to New York. If you've been here the past couple of days, those of you who believe in global warming will have evidence to that effect, will have had evidence to that effect. How many, just out of curiosity, how many people came to our last event last year? Just a handful. Okay, good. Then the talk I'm about to give will not be repetitive for most of you. My name is Bill Rosenblatt. I am the president of Giant Steps Media Technology Strategies, which is a consultancy located here in New York. And I am also the editor and writer and chief bottle washer of Copyright and Technology, the blog, copyrightandtechnology.com. So who produced this event? Well, Giant Steps. This is the blog. How many people have taken a look at Copyright and Technology? Oh, a lot of you. All right, great. It's free. It's there. You can get it by email or RSS, or you can look at the website. And then Gotham Media Ventures, which is Gordon Platt's organization that produces a lot of events, including the Digital Breakfast series, which is how I first met Gordon a couple years ago. So, what are we discussing today? What are we going to talk about today in the next 8 hours or so? We're really talking about what I call the interface between copyright and technology, which is a very rich area of subject matter for all kinds of people. And based on the fact, of course, that digital technology is used to make and distribute copies of content at virtually no cost, and that the copyright industries have various responses to this, which include legal, technological, economic, and educational responses. And we're really going to be talking mostly about the first two of those today, with a little bit of the third. My presentation this morning is really meant to bring those of you who may not be experts in this area kind of up to speed on what we're going to be talking about, to perhaps help you get the most value out of the day. I know there are a lot of people here for CLE credit and so forth. So we have some real experts here who are going to dive deep into issues, and I want to make sure that everyone kind of starts with a level playing field. So they're talking about technologies that affect copyright. There are several of them, most notably what we call DRM and conditional access, which fall under the heading of content access control. And then there are content identification technologies, which are used to identify content for purposes of filtering copyrighted material from various places, or for just managing royalties and licenses to that content. And then there is the technology of rights registries, which is actually something that Tom Rubin's going to talk about during his keynote address. It's a very interesting topic in and of itself. And then there are legal concepts that sort of interface with these technologies or affect them, including fair use, first sale, secondary infringement liability, liability of network service providers for copyright, legislation that makes it a criminal offense to hack DRM, known as anti-circumvention legislation, aka Section 1201 of the Copyright Act. And then there's the idea of blanket or statutory content licensing, which is gaining some interest in various quarters. These are all legal concepts. The ones that we're going to talk about, I think, most heavily today are the first two, and also a little bit, I think, maybe on the fourth one, third and fourth ones. So let's talk about technologies a little bit. Digital rights management. This is a term that was coined maybe around 1995. I wrote a book on it in 2001. It's a term that's been around for a while. Yet it has been called a troubled technology. And that the word troubled comes from a book called You Are Not a Gadget, which is published last year, written by Jaron Lanier, who's sort of a deep thinker who works for Microsoft most of the time. Very interesting book. So why is it troubled? Well, here's how I analyze it. There's another book called Code and Other Laws of Cyberspace from Lawrence Lessig, which is a classic now. It's his first book, in my view, by far his best book. And regardless of what you think of his ideas, it's really an excellent book. And on a couple of pages of this book, he lays out 4 factors that determine how cyberspace works, or how any society works, or any environment works. And those 4 factors are what he calls the market, the norms, which are behavioral norms, architecture, in this case meaning technology, and laws, of course, the laws. So, what are the problems with each of these factors that make DRM a troubled technology? Well, and I'll go through these, but you can see them here. The market factor that I think is most relevant here is that there is a great misalignment of economic incentives. Content owners insist on DRM in many of their licensing deals that they do, but they don't pay for it in most cases. Others have to pay for it. So device makers and network operators have found ways to use it to suit their own purposes instead of, or in addition to, those of copyright owners. And consumers have influence over all this only indirectly through the market. There isn't really a big consumer voice in these deliberations that go on, other than through market forces. So, in terms of behavioral norms, it's really hard to get consumers to change their behavior with regard to anything, but in this case with regard to how they consume media. And so these are just very rough estimates, and for apples-to-apples comparison purposes, they're US only, just because of the figures I was able to get. And they're very rough estimates, so don't, if you have a quibble with one of them, it's because it's a rough estimate. It's not an actual, these are not meant to be accurate in any way. But you've got basically a bunch of new services. These are exemplars of these services. They're not meant to be exclusive, or rather exhaustive. And you'll notice that they've kind of fall into 2 groups. The top group is business models that people understand as emulations of ones that they've known for a long time, such as radio, record stores, VCRs, and bookstores. And then there are ones that are really digital native models, video on demand, digital video on demand, subscription over-the-top video on demand, as exemplified by Netflix. On-demand music, whether free or paid subscription. And you'll see that the numbers are not as high as you get for the legacy model. So there's a ways to go here in terms of consumer education. Now granted, if you had put this same slide up 5 years ago, some of these numbers would have been 0, and some others would have been much lower. Another norm is that there are a lot of influences out there of users towards behavior that could be infringing. And the first thing that I have seen through the years is that the definition of DRM, as it was originally defined, which was a much broader definition than you see today, was really commandeered by the press. Yet, certain elements of the media have broadened it to mean any technology that restricts behavior in any way. People like Cory Doctorow and Mike Masnick of TechDirt, and one of them, I forget which one, referred to the special types of screws on Apple devices as DRM, which I think is stretching it just a little bit. There's also this notion that DRM means big media, which means either dinosaurs who don't get it or evil empires, which I think is also unfair. There's been a romanticism and rationalization of the hacker ethic, the pirate ethic, which I think has influenced behavior. And another point made in a new book called Free Ride by Robert Levine is that companies that like Google and so forth get the PR as being the free and open companies. These companies are referred to by Jaron Lanier as lords of the cloud. Google is not the only one. There are several. So, moving on to architecture, there's a real problem right now with technological innovation in the rights technologies space. DRM vendors have a hard time making revenue. VCs are scared off from it. And ever since 1999, when Ed Felton down in Princeton, my alma mater, was threatened with a lawsuit by the RIAA, a lot of researchers have been scared away from doing research in this area as well. And here's a little, again, pseudoscientific study that I did myself. What I did was I looked at IEEE and ACM journal articles over the last, I think, 3 or 4 years. I did this last year, so it was, let's say, 2007 through 2010. And I counted up the number of papers on rights technology-related subjects by country of origin, of the authors, the researchers. And I found, and then I compared it to a statistic that the OECD maintains called GERD, which is gross expenditures on R&D, as opposed to gastroesophageal reflux disease. And when you search Google or search Bing or search anything on GERD, you get, well, in addition to German people named Gerd, you get the acid reflux disease, and then you get this, which is the percentage of gross domestic product spent by each country on R&D. So what I did was I took a sort of normalized ratio of the amount of money that countries spend on R&D versus the amount that they actually put out on rights technologies. And I found something very interesting. Device-producing countries, Taiwan, China, and Korea. Spain is exceptional because they happen to have a very active research group at the University of Catalonia in Barcelona that puts out a lot of research. Those countries put out the bulk of the R&D right now. The content-producing countries, European Union, USA, also Japan, put out the least amount of this research relative to their R&D expenditure. So this, to me, is a problem. Another problem is that there are certain laws that are not amenable to technological implementation, such as fair use, which is something that lawyers tend to treasure as something that should be evaluated by courts rather than technology. And we had a panel on this last year, which I moderated, and I was trying to say, like, well, shouldn't there be some way of deciding automatically? And everyone's like, no, absolutely not, no way, no way. Privacy and due process have become issues, particularly in Europe, with the progressive response rules. There was this, the law in France, the Hadopi law, which now requires that all of the accusations of infringement be brought to a judge and are not automated. Anti-circumvention laws, I would argue, have reduced the incentive to develop effective technologies. The bargain struck in that law that was passed in 1998 was that the liability for a hacked DRM is solely on the hacker and not on the provider of the DRM. And this was borne out, at least at the appeals court level, in this case called Universal versus Ramirides 2000 over the DVD copy protection, where the judge said, the judge was asked to opine that, well, the CSS copy protection for DVDs is so weak that it shouldn't even qualify for protection under this law. And the judge said, no, I'm not going to go there. I'm not going to establish a bar for how effective what's called a TPM, technical protection measure, needs to be in order to qualify for protection under this law. And so copyright owners know that they have this legal backstop in case the copy protection is hacked. Yet, for all this, DRM is very much alive today, again, depending on how you define DRM. And what I used to say is that there is one major category of commercial media that doesn't have DRM, and that is, let me see if I remember this right, internet downloaded permanent music files. I'm missing one qualifier, but if you take away any one of those qualifiers, you're in a DRM environment. Now we have, it's a little bit more subtle. But if you look at this chart, you'll see that even in music, you still have copy protection or DRM or something of that effect in various business models, such as the mobile device offline listening mode model that services like Spotify offer. Most streaming services for music use stream encryption. Commercial video is encrypted in most release windows. Ebooks are mostly encrypted, whether they are downloaded or delivered via for example, the Google Book system, which are screenshots of page images. And then, of course, video downloads are all DRM'd. So the question I get all the time is, will DRM die? And the way I like to answer it is not when it actually enables new models. And here is just a list of some of the models that depend on some form of content protection. iTunes originally did, and then it of course got rid of DRM for music. Premium pay-per-view television is certainly a model. Early release window films is one model that succeeded. Music subscription services, as I mentioned, they all use some form of content protection. They just don't like to use the D word because it gets them bad press. There are subsidized content ecosystems that depend on some form of content security to sort of maintain their boundaries around their environments. One of them is Boink, which is actually a music service that I've been involved with for quite a while, and we're going to have the CTO of Boink, which is back there. He is, Richard Zinn, which is in beta now and very exciting, and he's going to talk about that during one of the panels later. It's a sort of subsidized content music service. And then Amazon has launched a free ebook a month to Amazon Prime members thing, which is another form of subsidized model. And then there is library ebook lending, which is a very, very popular model and something that couldn't exist without some form of content protection. So that's content protection. The other main type of technology that we're talking about today is content identification, which basically means two different technologies, complementary technologies. One is called watermarking, the other is called fingerprinting. Watermarking really means inserting or embedding some data into a content signal, audio, video, or still image, usually so that the user cannot perceive it. There are visible watermarks, but that's not what we're really talking about today. You can typically stuff a few dozen bytes into an image or video or audio item in such a way that it's robust and that the user doesn't notice. And by robust, I mean it's able to withstand various forms of torture, such as format change, analog conversion, cropping, color correction, distortion, etc. This technology first appeared for digital images in the mid-90s, and it's been adapted for audio and video subsequently. Fingerprinting is a somewhat newer technology. It really means examining content to determine its identity, meaning that there is no help, so to speak, in the form of something like a watermark embedded. You just look at the file and you do some analysis on the audio or video of it and determine its identity based on analysis of the waveforms. And you basically reduce the content to a set of numbers which you think of as the fingerprints, like taking the fingerprints of a person if they're, let's say, arrested by the police or something. And then you take those numbers and you look them up in a database of known fingerprints to see if there's a match. And how many of you are geek enough to understand what a hash function is? Okay, just a number of you. Well, fingerprinting is really a special case of hashing. It's also known as robust hashing or perceptual hashing. And it was introduced, the technology, the raw technology itself, or the patents date back earlier, but it really first got noticed in the content industry during the Napster litigation back in 2002, when it was proffered as a solution to making Napster copyright friendly, so to speak. A few years later, the music industry began to accept fingerprinting in certain uses, and then video fingerprinting technology, which is of course going to be more complex because video is more complex than audio, was introduced later. Civolution, for example, is one of our sponsors here, and that's what they offer to the market, among other things. They offer watermarking as well. And then there is a form of fingerprinting for text, which is basically pattern matching, which is out there, and the leading US company that offers that, there are others in Europe, is a company called Attributor, and the Associated Press and various other publishers use that. So there are many uses for content identification, many of which have nothing to do with digital rights. The two that do have to do with digital rights are the first two here, and we're going to hear case studies of these usages on the content identification panel today, which should be very interesting. So now let's talk quickly about legal developments and their potential technical solutions, which we're going to discuss today. So here are some that we're going to talk about today. We're going to talk about network operator liability, particularly in the music space. Free riding is a term that means a lot of different things, but in general it's taking someone's copyright and making money off of it without involvement of the copyright owner. And then there is this concept called digital first sale, which is a fascinating area, and we're going to have a fascinating panel on it, which unfortunately I'm not going to be able to watch because I'm moderating another panel parallel to that. But this is being videotaped, so I'll get to watch the panel on video. Secondary liability comes in various flavors, and for those of you who are not versed in copyright law, what that really means is if you infringe copyright, then you're potentially accused of infringement. And then there may be other entities that help you do it or look the other way while you do it. And those are potentially secondarily liable. And these are the definitions. The latest wrinkle in this was the Supreme Court decision in 2007, the Grokster decision, which took this concept of inducing infringement, which existed in patent law, and adapted it to copyright. So you can induce others to infringe by roughly having a business model that in which you make money by through the infringement of your users. Then there is this notion of liability, if any, that ISPs or network operators should have about infringements. And right now in this country we have this regime called notice and takedown, which basically means if you see your copyrighted work somewhere that you don't think it should be, you can issue them a notice saying, please take my work down. And if they take the work down quickly quickly or efficiently, then they're not going to be liable for infringement. There's another form of ISP liability that's been enacted in several countries called graduated or progressive response, which in the US, since we like baseball, we like to call a 3 strikes you're out policy, which basically means if you're caught infringing, you get a warning. You're caught infringing again, you get a stronger warning, et cetera, until potentially your ISP account is terminated permanently or temporarily, or your bandwidth is limited, or something happens to you. And as it shows here, there are several countries in here that have either implemented or are in the process of implementing such laws. And then here in the United States, there is something called the Copyright Alert System, which is being established. And there's an organization called the Center for Copyright Information, which is being established to administer that alert system, which is not an enforcement, but more like an informational system. So the technical solutions to network operator liability are potentially content identification and the analysis of network traffic. That's the tie-in between the law and the technology. Free riding can mean a number of things, as I said: monetizing links to copyrighted content, posting links to illegal content. So for example, if you're using a so-called cyber locker, such as 4Shared or Mega Upload, and you email or your friends, or you put up on a blog a link to a file that's on that service, then that could be a form of infringement. Monetizing content appearing in search results is something that some people would call free riding. And then there's a cloud, pun intended, hanging over some of the cloud music services about how they use content. And that's going to be discussed on the music panel with Nick Garnett this afternoon. So the technical solutions to those types of problems, fingerprinting and search is probably the biggest one. And I mentioned attributor. We have someone from attributor here. They do that. They use fingerprinting, well, so to speak, for text and search to solve that problem. The Associated Press has this thing called H-News, which is their way of tagging content so that it can be found in places that it might not supposed to be. And then there is a European standard called ACAP, which has to do with flagging what search engines should be allowed to do with content in terms of indexing and showing in search results. Digital first sale, I'm not going to go over this because we have a panel on it and you're going to learn all about it if you attend the panel. But basically, first sale is a concept in copyright law that says once you have legitimately obtained a copyrighted work, for example, you bought a book at a bookstore, then you can do whatever you want with it, and the copyright owner has no further claim on it, on your actions. In other countries besides the US, this is called exhaustion. We call it first sale. The interesting part comes in with respect to the fact that for digital downloads, the applicability of first sale is unclear. The Copyright Office was asked to sort of weigh in on this back in 2001, should there be digital first sale? And they kind of said, well, maybe someday, but not now. Well, it's 10 years later, the Copyright Office hasn't updated that in any way, and so we have an area that's being explored, and later this afternoon you will hear how it's being explored. So the technical solutions to this boil down to what's known as a forward and delete type functionality, which was contemplated in the 2001 Copyright Office report. And there are a couple of attempts to build such functionality now. One is through an IEEE standard called Consumer Ownable Digital Personal Property, and we're going to hear about that. There's a startup called Redigi, which has gotten some controversy lately, which is trying to do that for music. So there's some potential technical solutions for that, but it's still a controversial area. So now I'm going to wind up by just talking about what we're going to do today. We have the great pleasure of having Tom Rubin from Microsoft, and his talk is called Copyright at the Speed of Light, Creative Content and Cloud Computing. Then we have a plenary session sponsored by Irdetto called The Current State of Video Content Protection, Good Enough for Now, but Is It Good Enough for the Future? And the moderator of that session, Christopher Schouten, got stuck in Des Moines, Iowa on a flight cancellation, so I'm going to be playing Christopher Schouten today and moderating that panel. Then we split off into two tracks. The legal track will be here. The technology track will be in the other room. And so on the tech track, we've got a panel on the real world of DRM implementation. What does it really take to implement this stuff? Then we have a panel on the challenges of distributing content from multiple platforms and all of that entails. And then we have a panel on content identification, which is really a case study panel where you're going to hear about some really interesting applications of that technology. Then in the law and public policy track, we've got a panel on the Google book settlement, which is dragging on and on. So, you know, is it a good thing? Is it a bad thing? What's going to happen with it? And so forth. Then we have our first sale panel. And for those of you who don't know, the duck test refers to this notion that if a delivery of a digital work is done under a license that looks and feels like a sale of a copyrighted work, then should it be treated as a copyrighted work sale? So this is like, if it walks like a duck, waddles like a duck, and swims like a duck, then maybe it ought to be a duck. And then there's going to be a panel on certain new controversies going on in the music industry with regard to copyright law. So I would like to thank our sponsors again for making this event possible. Irdetto, Civolution, Arxan, the Copyright Clearance Center, and the law firm of Frankfurt Kernet. And once again, Arxan is raffling off a Kindle Fire for those of you who stop by their table and put your business card in. I also should mention that Copyright Clearance Center does a great conference called On Copyright, which for a copyright supporting organization is amazingly broad-minded as conferences go. It was a great event last year. They had a panel on appropriation art, which was completely non-judgmental. For those of you who know who Fred von Lohman is, he was a moderator. And Fred von Lohman is not moderate about anything. Very, very enjoyable conference that they put on. I'd also like to thank our media sponsors, the Association of Media and Entertainment Council, which helped us get the word out, and the Future of Music Coalition, which is an advocacy organization in Washington that mainly acts on the interests of independent musicians and songwriters. They also put on a terrific event called the FMC Policy Summit, which was held just recently down in Washington, also a really excellent event. And finally, I always like to end with a book recommendation. This is a new book by a guy named Robert Levine, who was, among other things, the editor-in-chief or managing editor of Billboard. And the subtitle of this is a little bit misleading. It's meant to incite controversy and all that stuff, how digital parasites are destroying the culture business, et cetera, et cetera. This is really I mean, he has his opinions, but what this is it is a fabulous example of business journalism about copyright and technology. It tells the story about both sides of this argument, and it basically lets the facts in most cases speak for themselves. And he gets a lot of facts together about things like who spends what on lobbying for whose organizations, and the deliberations that go on behind the scenes for various technologies, and fascinating read. Really recommend this book. I just finished it. It's going to be my corporate gift to my clients this year, actually, this book. So with that, what I would like to do is tee up Tom's presentation and then introduce Tom.